Sadly, we live in a world where there's a lot of crime, and the news is often full of the latest criminal activities. Important crimes like murder, when a murderer kills another person, are always in the news.
The basic definition of investigative journalism and how it is different from day-to-day journalism is that it tries to dig up things that some people are trying to hide. And so it's hidden. You have to go dig for it. And that needs a certain amount of training, it needs a commitment, it needs motivation. It also needs a kind of optimism and a belief in press freedom. Because a lot of people even journalists are getting cynical about the media, about democracy, about press freedom, about transparency. They're saying, well, we're all ruled by crooked people, the whole system is crooked, so there's nothing we can do about it. So you must have inside you a basic optimism and a desire to change, a desire for social reform, a desire to fight social injustice. So the technical side of it can come with training, but that inner motivation, that has to be there from before, I think. So the technical side of it can come with training, but that inner motivation, that has to be there from before, I think.
I show you how deep the rabbit hole goes.
Like you, be strong to hold the powers of the sun.
Listen to Pavarotti.
Can I be your superhero?
He may have friends on YouTube that he could have leaked it to, because they seem to know things that the defense is about ready to say a couple of days before the defense actually says it. And then they say it. All right, I'm going to make a prediction because it's floating out there. So there's a theory, right? There is a whole bunch of people that have been arrested. And let's talk about a drug connection to the house. There's this gang that is out there, and they are the Fetty Bros. And recently, in November of 2022, before the murders, they were sentenced to a long time in prison. These guys were running drugs up into Coeur d'Alene, Idaho, Washington, Seattle, all the way down in Mexico, all the way down, to the cartels. And so there was this big, huge investigation that took place by the DOJ, U.S. Attorney's Office. It was actually a HIDTA group. And there are three guys, and their names are, Hunter Bowe, Mealy, Caleb Carr, and Matthew Pena. So these three guys get arrested. Xana's mom, she must be the snitch. Xana's mom is a snitch for the feds. And if we hear about this in the defense and this alternate theory, okay, I just want you guys to remember, we're talking about it potentially tonight. So the Fetty brothers go down. They're taken into custody. Now, there's also prison gangs that are into the drug trade. AB, Aryan Brotherhood, which tends to be all white guys, and they have rules. And they have leadership, and they have structure. And they keep to those rules, and they keep to the leadership and the structure. And it's all based on, respect and doing the right thing. The Aryan Brotherhood gets taken down. That there are 10 defendants of AB that are taken down who took over from the Fetty brothers, the fentanyl trafficking and moving the drugs. Xana's mom and a couple other guys owe debt to AB and to the Fetty brothers, and therefore these four kids were murdered. I think that's where the defense is going to go. That's just my opinion.
Like, what do you think the alternate perpetrator is going to be?
I think it's going to be more than one, and I think they're going to try to run with the whole, purported drug house and some sort of either vendetta or gang style action that occurred.
Hello, welcome to The Revealing. I am your host, Pavarotti, and I'm here to discuss the Idaho 4 case. And folks, you probably want to hang around for this whole video because this one is going to be action-packed. We just got the new motion last night. I even sent out a post for it, for the motion to continue by the defense. And nobody should be shocked by this motion to continue if you've been following my videos. And it's interesting. A lot of people can't stand it when I toot my own horn, but you know, I put a lot of time and effort into researching this case, and you got to admit, I sure get a lot of things right. It's interesting to hear, you know, the professionals out there and their opinions on what the alternative perpetrator theory is going to be, and it just so happens to be mine. So that's a side note, but the things that we're going to discuss that's in this new motion, and I will break it all down for you, are things that are literally almost word for word that I've talked about in videos over the last few weeks. So we've got some things happening. Now, there are a couple things in this motion that I never even thought of, and they're brilliant for the defense. And we'll get into all that. But as I break this stuff down, I'm going to show you how the state caused this situation, and there is a remedy. All right, by the end of this video, I'm going to give you the remedies that I imagine are already being discussed among the officials. Probably a little bit of it was discussed in that hearing yesterday with, nobody wants to admit it, but with Mr. G, the only one whose attorney was actually named in that hearing. And there are remedies. There's two remedies. There's not just one now, there is two. But I'm going to go through and I'm going to show you how the defense has laid this thing out for a long time, leading up to having to file this motion that they just filed. And there can be no doubt that that motion that was filed to continue was already being written now for probably a couple of weeks. Then the Dateline issue, along with other issues that have come up related to busting that non-dissemination order, that was just icing on the cake that they were able to add to that. But I'm going to show you what this motion really is. This motion is a roadmap to go to trial at the trial date. But they're going to have to do some things for that to happen, because they will absolutely, if they don't, the judge will have to grant this motion to continue. And nobody wants to wait another year, especially Bryan Kohberger, and they have said this in the record. He doesn't want to wait one more day than he has to go to court. So the people out there that are saying this is a big ploy by the defense just to extend it out, Kohberger doesn't want to be sitting in that jail cell one day longer than he has to. So this is by no means the works of, you know, the defense trying to push something out. And we're going to break it all down in this one. On a side note, though, before I really dive into this thing, I got to tell Thrive on the Grid, and y'all, a lot of y'all know who I'm talking about. One of the things that you've been saying is, as you've been trying to put the records of it in the comments section, and I've never been able to see that, but I have listened to your comments, so I did what you did, and I took that picture and put it through a specialized reading software, and you're right. I got the JSON file with the license plate number. Folks, it's that car in the FBI report that we go over and we try to show the license plate on the green car. When that's put through some high-tech software to detect license plates, it reads the license plate number off the front of it. Now, it only gave like I think a 68% accuracy on what the actual number was. So I'm currently working to try to establish what that number really is, but it absolutely read a license plate number. And I'll just let you know that the license plate that it read started with the letter N. And in Idaho, when a license plate starts with N, that means Nez Perce County. So Thrive Off the Grid, I know you said you're kind of scared. Well, you don't have to be now, because you're not the only one that has that information. We'll dive deeper into that in the future. But on a side note, I got to tell you why when the green car thing came out and Lana and Mark B went through that, the first time I watched it, I went, oh my goodness. And, I latched onto it very strong. And the reason that I did is not because, I just saw that and it was so compelling to me. But the reason I latched onto it so strong is because I was actually keeping my eyes open for information about a car that was a different color. Now, I was thinking it was a silver car because that's what the defense said. But now that I've done all the research that I've done, and I know that a lime green car works like a green screen, like on YouTube, you have a green screen, or movies, they put a green screen behind you. That particular color actually has its own properties. So when you have a green screen colored car, it's going to show up on video as either white or silver. And the reason I was looking so hard when I seen this information the first time, and I went, this is it. Now I know that I've done a license plate reader like Thrive on the Grid, and I know that it read a license plate off the FBI picture. But when I go back a month to a video I did, as I was looking for this other information, I came across this. I didn't even remember saying it. But this is why I was so focused on that car being a different color. And when I found out it was green, it just made the most sense in the world. This is what I said a month or so ago, long before anybody ever found the green car.
Special Agent Immel's going to testify. There very likely are vehicles, light in color, white or silver, on all kinds of different cameras. Those could be Brady depending on what he has to say, but they should certainly be looked at. We're trying to look at that as quickly as we can to understand that. Vehicles, light in color, white or silver, on all kinds of different cameras.
Now, when I originally heard Ann Taylor say that in the hearing about different vehicles, either white or silver, it didn't register to me as important. And then yesterday, when I was putting together the video on the defense's vehicle identification specialist and his background, I didn't correlate the two. But when I was putting this video together and I listened to that again, and I heard her say vehicles either white or silver, well, then it immediately made my mind register to the video that I put together yesterday on the defense's vehicle identification specialist and something that was said in his background of qualifications. And now it kind of is starting to make sense to me. Check it out. So when we go to the article written by Stephen Becker about vehicle identification from photos or videos, confirming or refuting vehicle make and model in videos and images, when it gets to the part about the vehicle color may be altered by reflections, camera color enhancement, and ambient lighting conditions, yellow or blue lights, colors in video are digital and represented by several factors that represent the color displayed. In physical color analysis, paint can be chemically analyzed to determine a match. Digitally, we can analyze the following characteristics: hue, saturation, luminescence, red, green, blue, and content proportions. So the fact that she made that statement, white or silver, and the fact that Mr. Becker is an expert in determining the color of a vehicle on a camera really makes me start correlating the two where I wouldn't have done that before. We're going to talk about some of the things that I brought up because it's going to go hand in hand with this motion. So I want you to understand what we've talked about so that when we get into the motion, you'll see how everything goes together. And this is not a bad thing for the defense. This is taking some bad things that were trying to be done by the wrong group, and we're going to capitalize on this thing. Let's roll. I know the one that was the most important to the defense in this hearing was the motion to preclude the death penalty due to disclosure violations.
Let's address what I have is to be the last item, which is the motion to strike the death penalty regarding discovery.
Your Honor, we're asking the court to look at this not as a Brady violation, but as a due process violation. And it's important to understand a little bit more about the discovery to do that. First, I'll start with defense counsel's obligation. In any case, defense counsel has the obligation to meet its constitutional requirements of effective assistance of counsel, and that means that we have a duty to investigate any of the state's claims and review the state's discovery.
Okay, so the way that Ann Taylor started off this argument is very key. She started off with, this is not a Brady violation that we're arguing a due process issue for Bryan Kohberger. And then she went on to use the words that if you followed this case, you've heard her use probably 1,000 times. Effective assistance of counsel. It's real clear to me now why she has used that phrase so many times in the hearings, effective assistance of counsel. And it all comes down to this motion right here, folks. This is the motion that she had been prepping for to remove the death penalty for a long time. And those of you that have followed me know that I've really pointed this out specifically. And this is it. This is what she's going for in this. And the reason that she has to argue it as effective assistance of counsel and a due process issue is because that was the grounds that the Lori Vallow trial, the judge actually removed the death penalty based on those grounds, and it was a discovery violation. The thing is, with the Lori Vallow case, the judge gave her an option. She could either remove her effective or speedy trial, and they would keep the death penalty in place, but they would have more time to review discovery, or she could decide to not have the extra time to review the discovery and keep her speedy trial rights, and they would remove the death penalty. And that's what she opted for. That is what Ann Taylor is going for in this. And what I'm going to show you is what she has done to the judge right here. Is she has put his back in a corner, and she's going to make the judge make the decision. And I'm going to show you what that decision is as we go through this. But the Lori Vallow case, again, effective assistance of counsel and due process. In the Lori Vallow Daybell case, a judge removed the death penalty as a potential punishment for Lori Vallow, citing the state's late disclosure of evidence and potential prejudice to Vallow's ability to prepare for a fair defense. The decision was made to ensure Vallow's constitutional rights were protected, particularly her right to due process and effective assistance of counsel.
There's a heightened sense of that responsibility in a capital case. Death is different. That's been said time and time again throughout the United States and state courts as well. So we need to be able to review all of the discovery. We need to meet that obligation, and we cannot. 68 terabytes in our briefing. I won't repeat it all here, but
I don't have a clue of what's in there in some senses, because I don't know how much of that is music, how much of that is video and movies on personal devices, how much of that is things that no reason to look at.
Well, the problem is, Your Honor, there is a reason to look at it. There are tons and tons.
Why didn't you bring a motion earlier asking for intervention to have me do other things, and rather waiting to tie it to the death penalty at the end? Okay,
that little question right there by Hippler to Ann Taylor. Why did you not bring this up earlier and wait till the end? That was not a innocent question that he was just being inquisitive about. He asked that question for a reason, and the way that Ann Taylor responds to that question is very, very important, and I'm going to show you why here in just a minute, because that was his setup for where he was really wanting to go with this, because he knows what he's up against with this motion.
I'd say that's a bit of a mischaracterization of what's happened.
The first time we met, you told me about having received the state's discovery and the number of terabytes, and the first question I asked you was, have you looked at it? And you said no, you hadn't yet looked at it. And we talked about the trial date, and I moved the trial date back a little bit for that. And I haven't heard a word since then that you haven't had enough opportunity to review the discovery or to do the discovery.
Wrong again, Hippler. Shall I refresh your memory back to a hearing on removing the death penalty back in the day when you first took over the case after the hearing that you just mentioned?
Your Honor, we're asking the court to strike the death penalty in this case based on a conflict of constitutional rights and Mr. Kohberger having to face the choice between holding on to one constitutional right at the expense of another. And that's what's happened here. He has had to choose between his two constitutional rights, and those were effective assistance of counsel or speedy trial. The argument is the choice that Mr. Kohberger faced in August of 2023 when he had to choose to continue his case, thereby giving up his speedy trial rights, or go to trial on October 2nd of 2023, 10 months after being charged with this case, with completely unprepared counsel. And that's really the crux of this argument. And the remedy is for the court to strike the death penalty because Mr. Kohberger had to choose between rights, reinstate speedy, and reset a sooner trial date. That's the remedy. I want to talk about what happened and why Mr. Kohberger had to continue his case. The court's already heard a little bit today about the duties of counsel in a capital case and the kinds of investigations we must launch immediately. And discovery can be a really big deal, and I think the court is probably starting to understand just how big of a deal that is. Last August of 2023, when we were in that place where we had to make that decision, and there was a scheduling order from the prior court in this case that told us you have to continue it by this deadline, by this date, or you can't continue it and you're just going to go to trial. So I think we're positioned a little bit differently when we are truly in a place we have to give up one right to have another right. Had Mr. Kohberger gone to trial and stood on that right, his speedy trial right, and lost his right to effective assistance of counsel, there would have been more than a year's worth of discovery that his counsel would have not been able to know about. We have continued to get discovery. I think there's a bit more that continues to trickle in even past the deadline. I'm not arguing about that right now. But it's just a vast amount of information that Mr. Kohberger would have not had counsel prepared for. Well, I think you can consider what Judge Boyce did in the Vallow case, and that had to do with discovery that counsel didn't have enough time to review and to prepare for, and it would have disadvantaged the client. And so Judge Boyce in that case struck the death penalty.
That was as a result of the state having failed to provide the information, violating its court order. And then the remedies were, well, do we push trial back or not? And the choice that Judge Boyce gave the defendant was, well, we can go to trial, but I'll remove the death penalty because a lot of the discovery related to that. Or we can continue the trial for you to review that. So you can either go to trial with the death penalty, without the death penalty now, or you can expand it with the death penalty. One defendant chose one and the other defendant chose the other.
So eat your words there, Hippler. I just heard Ann Taylor say about 5 times about the issues that they've had from the beginning with the discovery, and she made you aware of it in a hearing on the death penalty, and specifically on the fact that they had to waive their speedy trial rights in order to wait to get the discovery so that there would be effective assistance of counsel for the actual trial. So the reason I wanted to play that entire segment of that hearing was not just to show that the judge, the statement he just made was completely false, and he can look at his own, recordings and see that that is a false statement. But also, I wanted you to see the brilliant move that Ann Taylor is making with this new motion. And I'm going to spell it out for you because it is very clever. And the reason I put, if you remember back when those death penalty hearings were taking place, I focused in on that specific portion of that entire hearing because I thought that was their best argument, because it did have standing with the Lori Vallow case. And it was a really good argument. Lori Vallow kept her speedy trial rights in lieu of getting rid of the death penalty and not having all the discovery to be able to go over by trial. And that's what Ann Taylor was trying to do with that motion. She said, look, here's the remedy. Reinstate speedy trial, move the trial date up, and get rid of the death penalty, and let's just do this. But the judge overruled that motion. So what did Ann Taylor do? Well, she waited for the prosecution to pull another move and not meet the deadlines on their discovery obligations as it relates to these new things that have taken place, like the Barbie dollhouse and other affidavits that they've submitted from experts. See, they're bringing in things now that has passed the discovery deadline. So Ann Taylor has been buying her time. And you heard in that first hearing I just played for you that she said, I'm not arguing this now. Meaning she wasn't arguing the discovery violations now. She was arguing the fact that she had to make a decision on speedy trial, or Kohberger did, on speedy trial or getting the discovery. But she wasn't making the argument on the discovery violations now. And that's because she was waiting for now to do that. He knows the decision that he's truly going to have to make. And I'm going to show you that here in a minute. If this proceeds as a non-capital case, heightened due process is not required, nor will heightened scrutiny be applied on appeal if a conviction results. And thus, all parties are more likely to obtain a final outcome at trial, meaning take off the death penalty and that portion of it. Thus, the prejudice to the prosecution in precluding the death is relatively small. They can still seek a death in prison sentence. On the other hand, the prejudice to Mr. Kohberger in proceeding to a capital trial under such circumstances is unconstitutionally grave. Now, this is the key part. While the prosecution seemingly suggests, without the fortitude to make the outright request, a continuance as a remedy, state's response at 9:10, that is not a fair nor a sufficient remedy. Mr. Kohberger is being held without bond. It is patently unfair to restrict his freedom for months or years to come in order to fix a problem that has been and continues to be within the government's control. While the prosecution seemingly suggests, without the fortitude to make the outright request, a continuance as a remedy. All right, so let me see if I can wrap this up in a bow for you, because they didn't adhere to their deadlines, just like in the Lori Vallow case. And we have to stop what we're doing and go and look at everything that's new that they're bringing in after the deadlines. That takes away from the time that we had allotted to try to go through the discovery. So now there's no way we can go through the discovery because the state has brought in new information past its deadline. But even more so, that created the perfect argument that went along with the Lori Vallow case. The only difference is in Lori Vallow's case, she did not waive her speedy trial like they forced Kohberger to. So the argument from the state, Bill Thompson, and their limine was precluding the death penalty is not the right remedy. The right remedy would be to push the trial date back and give the defense more time to be able to go through that discovery. Ann Taylor, anticipating that though, she went ahead and she created her own speedy trial date. You can see in that motion, she said, look, Bryan Kohberger is sitting in jail with no bond. We don't want to push this thing back any further. Now she's talking like the state should be talking. We want to go to trial now. We don't want to push this thing back. We want it to start right now. We're not going to be able to go through the discovery, but we're not going to push it off any further. So the remedy is remove the death penalty so that we don't have to focus in on the mitigation. You don't have to worry about an appeal. There's all kinds of benefits, and you can still seek a life in prison death sentence, basically. So they have taken Judge Hippler. Think about this. He set the trial date, and he said that trial date is going to happen no matter what, and he wants everything done before that trial date because nothing's pushing it back. Now, what Ann Taylor has done is she's used Judge Hippler's set-in-stone trial date against him. You see, that became the speedy trial issue. So Kohberger doesn't want to push the trial out any further. The state is recommending it. The judge doesn't want to push the trial out any further. But the defense has laid out this argument so perfect that this judge is going to have to make a decision. And the decision that he is going to have to make is, does he bend on his trial date, push it out further, or will he bite the bullet and remove the death penalty? Now, some of y'all may remember that video, and I'm sorry I had to make you watch it twice before I get into this doc, but you clearly have to understand where we're at in this and what led to it. In that, like I clearly laid out, that the defense gave the judge the choice. And the prosecution, it even alluded to giving them a continuance to go through the discovery. So I laid it out. I said, look, here's the judge's decision on the motion to preclude the death penalty. He's either going to remove the death penalty and they can go to trial because they don't have all the extra things they have to do with the mitigation, or he's going to deny removing the death penalty, and the result of that is going to be a continuance. And I said, it's his decision to make, and we all know the decision that he made. He made the decision just to wipe it out and decline, deny the motion to preclude the death penalty. And we had to know that once that happened, this was going to be the result. So the filing that the defense just filed, it's 40 pages. There's no way that they just drafted this 40 pages because it's written very well. I mean, very well. And there's no way that they drafted it all here since the Dateline leak. They've been working on this since the day that the judge denied the motion to preclude the death penalty. Now, since the Dateline leak, you can bet they added that in there. And as we go through this new filing from the defense, I'm going to point out some very, very important things. I'm going to point out the 3 things that we need to take away from this document. And it'll clearly spell it out as we go through it. So there's 3 things that we need to take away. But then at the end, I'm going to show the 2 things that could happen right now that would remedy this situation and allow this to go to trial. Actually, 3 things. There's 3 things we need to take away, and there's 3 things that would remedy the situation. And once again, it's back on the court for them to do those 3 things to get us right back on schedule. Let's go to that court doc. Okay, so the 3 things that we're going to look for in this filing are also the 3 remedies that must be done for the trial to commence on the trial date. And number 1, remove the death penalty and the obligations that a defense team has as it relates to the mitigation aspect of the case, and that's no longer necessary. Therefore, a non-death qualified jury can be seated, and they are more representative of the public and more likely to be open-minded during the guilt/merit phase of the trial. So, step number 1, remove the death penalty and all the obligations that go with a capital case so that they can seat a proper jury. That's remedy number 1. Judge does that, they'll be 1 step closer to going to trial on August 11th. Number 2, have all of the leakers of the evidence come forward and then bar them from being potential witnesses for the state during the trial. They are either going to have an investigation and find these leakers and then bar them from being potential witnesses for the state, or they can man up, come forward, and then disqualify themselves. So if they have to do an investigation, this trial is going to be a long way off. If they just come forward and bar themselves from being potential witnesses, we can move along as scheduled. And last, they got to stop the release of the new James Patterson book from being released 2 weeks prior to jury selection. That one is going to kill jury selection and due process rights of Bryan Kohberger. Those are the 3 things we're going to look for in this filing, and those are the 3 remedies that would have to happen for this thing to go forward on time. Okay, so we're going to go through now this motion to continue. And we're going to focus in on the first part, which is what I just had you watch in a video from a month ago that will clearly spell out what the defense was trying to tell the judge. It was trying to tell the judge, we're ready to go to trial, but the mitigation, there is so much involved in that, there's no way to get it done by the time we go to trial. And if we have to focus on the mitigation, we cannot do the work we have to do on alternate suspects and preparing for the guilt phase of the trial. It's one or the other, and it's up to you to decide. And he decided. So, but they're still going to go through this and point out all of the things about the capital case and the death penalty, so it's clearly still a remedy to remove the death penalty to move to trial. But comes now, Bryan Kohberger respectfully submits the following motion to continue due to the substantial amount of trial investigation and preparation still outstanding, as well as recent and forthcoming publicity that is highly prejudicial to the defense. In making this motion, Mr. Kohberger relies on his right to be free from cruel and unusual punishment, his right to due process, his right to a fair trial, his right to counsel, his right to present a defense, his right to confront witnesses, his right to a fair and reliable sentencing determination, and other rights safeguarded by the 5th, 6th, 8th, and 14th Amendments to the United States Constitution. And then when we get to the table of contents, you're going to see that all of this, all of it, has to do with all of the additional work that is required by a defense team in a capital case when the death penalty is on the line. All of this. And when you go through and read this, and I'm not going to read all this to you because it's just going back and reaffirming how much they have to do, then you clearly understand why it would take 3, 4, 5, 6 years before you can go to trial on a capital case, because they have to have all this done according to the guidelines. And all of this, you have to go all the way to right here before it even interjects about the publicity with the dateline. All right, so this motion was being crafted long before the dateline leak, and it was all about that decision that the judge made. If he did not remove the death penalty, that just like the prosecution stated, then they would need to file a continuance. It was all on the court. The judge made his decision. Now he's going to have to make another one, this time a lot more on the line for it, though. And in the argument, you can see the trial court is obligated to uphold Mr. Kohberger's constitutional rights by vacating the trial date, because defense counsel needs additional time to review discovery and prepare for the complex merits and sentencing phase unique to death penalty cases. You see, they were fine with going to trial on the merits, but to do the merits and the sentencing investigation, they can't put enough time on both of those at the same time. It's impossible. And as you read this motion, you'll see that it's impossible. As detailed in this motion, moving forward with a capital trial in August will infringe upon Mr. Kohberger's constitutional rights, as counsel requires more time to review discovery, complete investigations, and prepare for trial. When considering this request for a continuance, the court must weigh the issues against the heightened need for reliability in death penalty cases. That'll be a recurring theme over and over. Death is different. When the state seeks the death penalty, it imposes an extraordinary burden upon the court itself and defense counsel to ensure the fairness, accuracy, and reliability of the trial and any subsequent sentencing proceeding. The Idaho Supreme Court, rule of the law of the land, 2, has emphasized the special safeguards and stringent due process protections that must be afforded in capital cases. Again, capital cases. And the qualitative difference between death and other penalties calls for a greater degree of reliability when death sentence is imposed. It's all because they want the death penalty. And in capital cases, the rights to effective assistance of counsel and a complete defense are amplified. Recurring theme, right? The 6th Amendment entitles Mr. Kohberger to the effective assistance of counsel at both the merits and the penalty phases of this capital case. In a capital case, counsel must meet specific professional obligations to be constitutionally effective, so they have to meet them. The ABA guidelines, that's who sets out the guidelines of what they have to do. They outline the professional expectations and obligations for counsel in death penalty cases. Remember, only a death penalty qualified attorney can represent their client in a death penalty case. And that's because of all of these additional guidelines that are required on them in the merit and guilt phases of a capital case. Everything is heightened. When you hear Ann Taylor say this over and over, it's not like you hear other attorneys say in cases where they're not going for the death penalty. The stringent rules and regulations of what they have to do as a defense is multiplied, exponentially. In addition to the effective assistance of counsel, Mr. Kohberger has the right to a meaningful opportunity to present a complete defense. This right takes on special significance in capital cases. The right to present a meaningful defense must take precedent over any countervailing state evidentiary rules or procedures that might be acceptable in the context of non-capital criminal cases. So the death penalty is different. So I don't know why everybody has such a hard time with this, because the prosecution is seeking to execute him. Mr. Kohberger also has additional constitutional rights in this proceeding. So it's not like the rights of normal defendants there, McDonough. When a jury is denied relevant mitigating evidence, either because counsel independently fails to conduct a complete investigation or because the court denies defense counsel adequate time or resources to conduct such an investigation, the defendant's rights under the 6th, 8th, and 14th Amendments of the U.S. Constitution, as well as the corollary guarantees in the Idaho Constitution, are violated, and any resulting death sentence cannot stand. Now, it gets into all of the things, and I'm not going to read this all, but it is amazingly complex, the mitigation investigation that has to be conducted in a capital case. There's no way you could do all that it's talking about here with a team of individuals in less than several years. And counsel's duty to provide effective assistance to counsel in accordance with the prevailing professional norms. And then it goes into it. Very task ordinarily performed in the representation of a criminal defendant is more difficult and time-consuming when the defendant is facing execution. They continue to state that over and over and over. Now, right here, I want to talk about this for a second. The minimum requirements counsel must meet in investigating for the merits phase of a capital case. All right, so when they're just talking about the guilt phase, not even if he was found guilty, there are minimum requirements that the defense attorneys must do just for the guilt phase, not even the sentencing phase. And then it talks about them. With respect to investigation for the merits phase, that's the guilt phase, the ABA guidelines are clear that counsel must thoroughly investigate and challenge every minute piece of the evidence the state purports to have. So when the judge says some of that discovery is just, cumulative videos or, music that they've downloaded on a digital device, I don't know that it's relevant to the case. Well, it doesn't matter, Judge, because the ABA guidelines say counsel must thoroughly investigate and challenge every minute piece of the evidence the state purports to have when it is a capital case. So is this judge a capital judge? Because he doesn't seem to understand this. To assume the accuracy of whatever information the client may initially offer or the prosecutor may choose or be compelled to disclose is to render ineffective assistance of counsel. The defense lawyer's obligation includes not only finding, interviewing, and scrutinizing the backgrounds of potential prosecution witnesses, but also searching for any other potential witnesses who might challenge the prosecution's version of events, and subjecting all forensic evidence to rigorous independent scrutiny. Now, we know that hasn't taken place in this case. In addition to a complete investigation of every piece of the state's case, counsel is then responsible for identifying and considering all legal claims potentially available, even if those claims have consistently lost in that jurisdiction. So when they talk about, like the judge told Logsdon, he said, yeah, when they were doing the death penalty motions, he says, yeah, I know you've tried this in other cases all around. He said, you've been unsuccessful in all of them. He was being condescending to Jay Logsdon when he said that. And it says right here that it is their responsibility of the defense counsel to file every single one of those claims, even if they already consistently lost in that jurisdiction. So they have to do it. It's their responsibility. So all of these talking heads out there that say Ann Taylor's tried to throw everything against the wall to see what sticks, they're required. That's her doing her job. These people need to either get off the airwaves or go to law school and learn something. Counsel should object to anything that appears unfair or unjust, even if it involves challenging well-accepted practices. Anything. This is necessary because counsel in a capital case has a duty to preserve any and all conceivable errors for each stage of the appellate and post-conviction review. Non-preservation of an issue at the trial level may result in waiver and ultimately in a defendant's execution, even if reversible error occurred. And then it lists describing a case in which, from a joint capital trial, I remember reading this in the motion, one co-defendant was eventually executed because his counsel failed to object to a woman being excluded from the jury, while the other co-defendant's case was reversed and he's now serving life in prison because his attorneys preserved the issue. So every little thing matters. This obligation places a significantly higher burden on defense counsel than in non-capital cases. In an ordinary criminal case, one without the death penalty, counsel could strategically forego some aspects of the exhaustive investigation outlined step by step in the ABA guidelines and would not be required to preserve every possible legal error for potential review. Furthermore, there would be significantly fewer legal issues to address because the unique issues related to capital sentencing would be irrelevant. The defense is clearly stating their remedy once again in this statement: remove the death penalty. But they're also stating all of the additional things that they have to do as part of their job as a death-qualified defense attorney. So when you hear Moron say things like this,
Ann Taylor wants the trial delayed due to the substantial amount of trial investigation and preparation still outstanding, as well as recent and forthcoming publicity that is highly prejudicial to the defense. So apparently they haven't been doing their job, is what she's saying.
no, guy, they are absolutely doing their job. Maybe you should, instead of interjecting your opinion at the motion to continue statement at the header, maybe you should read that entire document and learn what they're required to do in a death qualified case, and then make your assertion of whether they're doing their job or not. That way you're a little bit more educated on the subject matter. But I watched you try to read that, and no, you wouldn't be able to. So, yeah. Okay, then it continues to go into counsel must conduct an exhaustive, unparalleled life history investigation, analyze hundreds of documents and interviews, compile all this information into a cohesive narrative for the sentencing phase. So, and it will go through and list all of the additional things that they have to do on a death penalty case in the mitigation part of the case. Things that are required, following the guidelines. And it is immense. So, adding to the complexity, it has long been recognized that a competent mitigation investigation must include the family history. They have to go back 3 generations. It must document genetic history, patterns, effects of familial conditions. And this is all required in the ABA guidelines. It is immense. I read all of this, and I was floored actually after reading all this. So we're going to go down to right here though, because now it gets interesting. And you can see this footnote in here. And this is my favorite footnote of this document. Of course, a sentencing phase only occurs if the jury has already found the defendant guilty of capital murder beyond a reasonable doubt in the merits phase. Counsel does not suggest that conviction is a foregone conclusion of this trial. So we're not even suggesting that conviction is a foregone conclusion. What they're stating is they know that they're going to get a non-guilty verdict, but because of the requirements of being a death-qualified attorney, regardless of how they feel about the merit phase, it is required of them to do all of the things in the mitigation investigation. If you remove the death penalty, it removes those requirements, and then we can go to trial on just the merits. But the judge should have removed this thing at the motion to preclude the death penalty due to disclosure violations, and he would have saved himself a lot of time and a lot of effort. But he had the decision. I clearly laid it out. He knew what his decision was, and he made the wrong one. As we keep going, it's going to talk about where their efforts have to be put because of this mitigation investigation. There are numerous examples of capital case reversals because counsel failed to complete the social history investigation. Even when competent experts have been hired, because the evaluations resulted in inaccurate or incomplete information presented to the sentencer. So even though they hire competent experts to do the mitigation investigation, if it results in inaccurate or incomplete information, they can reverse the capital case. And that's what everybody's trying to avoid in this thing, right? Having to do it again. Therefore, the investigation into the individual's life history must be completed before counsel can know the full spectrum of necessary experts for the penalty phase. So they have to complete an investigation into the life history to even know what experts they need to hire to be able to complete the mitigation for the investigation into the penalty phase. It is unreal. Counsel requires additional time to fulfill the minimum requirements described above. The minimum requirements. Counsel cannot review all of the relevant discovery and complete the necessary investigations prior to trial. Why? Because they would have to take their eyes off of what's important in the guilt phase and put all eyes on the penalty phase. As counsel explained in recent filings and in oral argument, which are hereby incorporated in full for brevity's sake, it is impossible for the defense team to review the necessary and relevant discovery in a manner that allows the evidence to be integrated into the comprehensive defense case, to pursue all necessary investigations arising from review of the discovery, including into alternate perpetrators, and to address the myriad issues that continue to arise from the state's failure to fully abide by this court's discovery and expert disclosure deadlines, just like we touched on in the video prior to this. Counsel requested that this court alleviate these problems by precluding the death penalty as a possibility. Remember, if they preclude the death penalty, then the defense is not required to go into so much detail in the discovery, even into the alternative perpetrator investigation. But because it's a death-qualified case, they're required to review each and every piece of the discovery. That's why Ann Taylor kept saying that. I've got to go through this stuff because I am the death-qualified attorney. Freeing up counsel's time to focus only on the merits phase preparation and removing the heightened standard of reliability that governs death penalty proceedings. Because the court denied that motion, counsel is obligated to seek a continuance to continue review and discovery, just like they said they were going to have to do if you didn't follow through on that motion. Complete investigations relating to the merits phase, including into alternate perpetrators, and complete investigations into red flags that have arisen in the life history investigation. They have to go through it. They cannot not go through everything for both phases because it's a capital case. The prosecution has not provided defense counsel with a list of potentially exculpatory or impeaching evidence within the vast tranches of discovery in this case. And the court declined to order them to do so. During oral argument on that motion, the court identified a practical problem with relying on prosecutors to identify and list all exculpatory and impeaching information. Prosecutors are advocates of their side and see the case through the lens of trying to secure a conviction. Thus, what may appear exculpatory to a defense attorney or lead to the discovery of exculpatory evidence through additional investigation may appear only tangentially relevant to a prosecutor, given the heightened standards of due process afforded to a capitally accused defendant. It is imperative that counsel has time to review the relevant discovery and conduct any necessary follow-up investigations. So what Ann Taylor is trying to say is she was fully prepared to take this to trial, but because of the extra obligations of the death penalty, if the death penalty was not removed, and I believe their plan was to have it removed with the precluding of the death penalty due to discovery violations, and when that failed, well, everything goes out the window and this trial has to be continued. So the judge made this decision. Cutting off this review before counsel can complete it would significantly prejudice Mr. Kohberger. The state's case is circumstantial. Mr. Kohberger was not identified as a person of interest until weeks after the crime, and after he was identified, law enforcement ceased investigating all other possibilities. While counsel can explain this in trial, every experienced trial lawyer knows that trials are essentially story battles. High-stakes duels where the prosecution and defense each tell competing narratives about the same set of events. Ultimately, the jury decides which story feels more true and more coherent. Even though the burden of proof rests with the prosecution and the defense bears no burden at all, humans are driven by narratives. That reality forces the defense to counteract the state's narrative with another compelling story. As scholars explain, where the central issue is the identity of the perpetrator, even a reasonable doubt case implies a story that someone else did it. But it is a story with a huge hole and one likely to be ineffective. The jury might speculate that if this defendant did not do it, there should be at least some evidence suggesting that someone else did. And it is especially incumbent on counsel to become aware of all existing evidence, because alternate perpetrator evidence may be deemed inadmissible under the Idaho law if it merely tends to mislead the jury that another person committed the crime. State versus Meister. Bill Thompson at 11, poor Meister is still sitting in prison and he didn't do it either. Thus, defense counsel's review of the discovery is not merely checking a box. It goes to the very heart of the ability to prepare and present a defense. Reviewing and integrating all of the evidence in order to tell the jury a coherent narrative, counter-narrative, is essential to defending Mr. Kohberger's life. The state and its superior investigatory apparatus has spent years honing in on one specific story, that of Mr. Kohberger's guilt, and ignoring all other possibilities. Defense counsel has a bigger job in not only reviewing their case for guilt, but figuring out what the state missed and exploring other alternative possibilities. The inability to review the discovery and incorporate all of the information into a cohesive defense prior to trial would nearly guarantee that counsel cannot mount an effective defense on Mr. Kohberger's behalf. Because his life is on the line, death penalty and due process must be given its highest regard. This court should grant counsel the time necessary to ensure a fair trial. Absolutely. And it's the judge's decision to put you in this position at this point, and he has no choice but to either remove the death penalty or grant the continuance for an extended amount of time. Now, we're going to get into the meat and whatever. Now we're going to get into what's really interesting to everybody, and that is this new Dateline crap. A continuance is also necessary to investigate and remedy the prejudice of highly inflammatory publicity released just weeks before the current trial date, including the recent Dateline NBC special. It says including. That doesn't mean all of it, Mr. G and all of the other mainstream morons out there. This just says including the recent Dateline and a forthcoming book. But we're going to focus in specifically on this recent Dateline and what really happened in this thing, just like I said the other day. Remember I said this a few days back, Dateline, because the defense would want, evidence out there from the case in the hands of people that will not only take the evidence and display it, but they will take the evidence, display it, and then add their opinions around it. See, it wasn't nothing about any of that stuff that was disclosed on Dateline that was damning to Kohberger. The thing that was damning to Kohberger was the narratives that they actually narrated around those things. Because if you were to take those things at face value, they wouldn't have any value. Oh, the evidence came out. No, it wasn't the evidence. It was the fact that the things came out and then they added their narratives around the evidence and told a story with it. That is what was egregious. Now, remembering that, look what Miss Ann Taylor has written in this document. This case has garnered substantial public interest, and the court previously issued a non-dissemination order restricting the release of certain information to the public in order to preserve the integrity of the proceedings and safeguard Mr. Kohberger's right to a fair trial. On May 9, 2025, just weeks before this capital trial is set to begin, Dateline NBC aired a 2-hour episode about this case titled The Terrible Night on King Road. The program includes details and materials, including video footage, cell phone records, and photographs of documents that are not publicly available through official channels. The show repeatedly emphasizes the non-public nature of this information, stating it was obtained from unnamed sources who are close to the investigation, and that the materials were obtained exclusively by Dateline. Much of the investigative material presented by Dateline was taken out of context and will not be admissible at trial because it lacks reliability, because it was just pictures and Google searches that doesn't have any context around it. So when you take it out of context, and I love how they put, I watched McDonough read this, and he said, I don't know, he said these were parentheses, number one, and it meant that it was true. I'm not going to play his video, but he said these quotations were parentheses, and it meant that the evidence was true. No, genius. These are quotations. It means investigative, which means it's kind of like a slight towards their investigation. Like it's not a real thing. It's their investigative. It's sarcasm. Genius. But this investigative material by Dateline, it was all taken out of context. And how did they do it? Just like I said, with their narratives. The leaked materials appear carefully curated to promote a narrative of guilt. Right, when you add your stories and opinions around the information, you can make it look nefarious. As this court acknowledged in its May 15, 2025 document and records hold order, the source of the leak is most likely someone currently or formerly associated with law enforcement or the prosecution team. If that is the case, it raises urgent and serious questions about the objectivity, judgment, and credibility of the individuals tasked with investigating and presenting the state's evidence. So what the defense is saying right here is if it's proven that it was somebody currently, formerly associated with law enforcement or the prosecution team, then they have just destroyed the credibility of all the individuals tasked with investigating and presenting the state's evidence in this case. So the defense is saying those people have ruined the credibility of the entire state. Particularly, though, those who may be called as witnesses. So this is remedy number 2 right here. Figuring out who the leakers were, and whoever they are not to be called as witnesses in this case because they have ruined their credibility in the investigation. And if they can't call them as witnesses, then they can't provide what's called foundation for a lot of the state's evidence related to each one of those witnesses. That is huge, and that is a remedy that has to happen. The identity of those involved, their motives, and any efforts to conceal their conduct go directly to the heart of witness credibility and the integrity of the state's case. So whoever those leakers are, once they're found, that is the big penalty, is they're not going to be able to testify in this trial. The apparent leak is not only egregious. What? The apparent leak is not only egregious. What did I just say? That is what was egregious. It's not only an egregious violation of the court's non-dissemination order, it enabled Dateline to gild rampant speculation with the veneer of credibility. When purportedly exclusive information surfaces through a media broadcast shortly before trial, particularly information attributed to unnamed sources with access to the investigation, it carries a heightened aura of credibility and secrecy that can deeply influence public perception. Unlike official disclosures, which are typically accompanied by context and procedural safeguards, leaks framed as exclusives are perceived as uncensored truths that the public was not meant to see. This insider framing enhances the material's persuasive power, suggesting that it is both authentic and revealing of the case's hidden realities. This episode includes things such as repeated speculative assertions regarding the assailant's motives, including unfounded allegations of sexual motivation. And who did all of those unfounded allegations of sexual motivation? It was the 2 regulars on McDonough's show that thinks everything stimulates people.
A sexual excitement, being stimulated by torture, like a paraphilic disorder where you're sexually aroused, on the internet.
Right.
What looks like a period of a gestating fantasy. There's a sexualized component where you're less overtly sexual, you're kind of inadequate, you get that godlike feeling. Was the knife chosen because it was a kind of compensation for sexual inadequacy? Is it an extension, a phallic instrument? Is it chosen for that reason? Because I think this is a profoundly sexually inadequate person.
This was definitely a sexual homicide.
Had a lot to do with some expression of sex, as a sexual component, and be sexual in a normal way. I think there must have been a sexual heating up, that if there was peeping, that there wasn't a sexual component to that.
Intentional, maybe to go in there and to sexually assault and to do that. Sexual fantasy.
You got to admit, that's a creepy photograph.
Being stimulated.
Those are literally, as Ann Taylor's about to describe them, as the so-called experts that Dateline chose to narrate the so-called evidence that was leaked. You've got to be kidding me. Dramatic reenactments and animations depicting the alleged crime created by the show's producers without basis in the evidentiary record. So like when they say that Xana was running upstairs as Maddie and Kaylee are being unalived, and then he chases her back down, unalives her and Ethan. This is just dramatic reenactments and animations created by the show's producers. There's no basis in evidentiary record. People actually believe that crap. Emotional interviews with individuals connected to the alleged victims, accompanied by evocative music, photos and videos designed to elicit strong emotional responses. The broadcast repeatedly bolstered its speculative claims through the use of so-called, that's Bricado and the other guy, so-called expert commentary. So-called is another way to say they ain't experts to nothing. including individuals identified as law enforcement professionals and academics. Yeah, they are neither. These commentators were permitted to make sweeping assertions about the defendant's alleged motives, psychological state, and personal history, as you just heard me display what they had said on other people's broadcasts, none of which are grounded in the evidence before the court. So they made all that crap up, while the program repeatedly emphasized their training and research and years of experience to lend undue credibility to their conjecture. So Ann Taylor's calling all of those guys a bunch of jacks. This type of testimonial mimicry improperly mirrors expert witness testimony. Improperly. Like these guys are not experts, but it improperly mirrors expert witness testimony. In other words, it implies that they're expert witnesses and they improperly mirror it. So it's a bunch of jacks acting like experts in a trial setting without the safeguard of cross-examination or evidentiary standards, effectively presenting the public with a one-sided, unvetted narrative that shapes juror perception before any admissible evidence has been presented. So they went in, took benign evidence and egregiously added the idiot's opinions around it and made something that was benign look egregious. I mean, look sinister. While the program occasionally inserts disclaimers such as, "We don't know what happened," these brief caveats do little to mitigate the cumulative impact of an extended narrative constructed through selective imagery, emotionally charged reenactments, and detailed speculative descriptions of the crime. Speculative. When viewers are presented with a cohesive, visually reinforced sequence of events, especially when paired with commentary from individuals styled as experts. Not experts, but styled as experts. The overall presentation fosters a sense of authenticity and truthfulness that is difficult for morons viewers to disregard, like guilters. An occasional passing verbal disclaimer functions more as a legal formality than a meaningful check on prejudicial perception. And most viewers will leave with the impression that they have seen reliable reconstruction of events. So the guilter rate out there, I think they said is 90-10. So that would include most viewers getting that 90% guilter rate and believing the bull crap that they see. The Dateline special, which aired just weeks before the trial date, will not even be the last pretrial media bombshell. Best-selling crime author James Patterson has written a book about the murders entitled, imagine this, The Idaho 4, An American Tragedy. Scheduled for release on July 14th. They were going to schedule it, less than 2 weeks before they started seating the jury. What kind of crap is this? Are they trying to pull in this thing, y'all? Just 16 days before jury selection slated to begin. Amazon tells you about it. The blurb for the book describes Mr. Kohberger as a brilliant grad student, loner, apparent incel. Are you kidding me? And explicitly tells the reader, now you are the jury. The evidence is in. The publisher boasts of unmatched access to the investigation. More leaks, including interviews with local law enforcement, all the leakers. Every one of them should be disqualified as a witness in this case. This suggests that the apparent Dateline leak was not only violation of this court's non-dissemination order. No kidding, it wasn't the only one. Dateline, James Patterson, all of the G leaks. I mean, goodness, this whole case is one big leak in violation of the non-dissemination order. Let's look up James Patterson's book real quick. Wow, looky here. Based on hundreds of exclusive interviews, the definitive account of the murders of 4 unforgettable college students by a cold-blooded killer. The Idaho 4, An American Tragedy. James Patterson and Vicki Ward. Looky here. Look, it's hardcover. You get it by July 14th, right as jury selection begins. Isn't that something? Look, the murders of 4 innocent college students attending the University of Idaho left us with so many questions. Now, after more than 300 interviews, James Patterson and prize-winning journalist Vicky Ward finally have some answers. We know what it was like to live in Moscow, Idaho on November 13, 2022, the day of the cold-blooded killings. We know what the local police and FBI did right and what they did wrong. We've learned so much about the 4 heartbroken families, the Mogans, Gonzalez, Kernodles, and Chapins, and we have the backstory for Bryan Kohberger, brilliant grad student, loner, a parent incel, now indicted and facing trial. Now you are the jury. The evidence is in. Well, I wonder if this is going to be a hit piece, considering they've already called Kohberger an apparent incel. They've got so much they've learned about these 4 heartbroken families. I wonder if they've dove into their criminal history and their, you know what, I ain't even going there. But this thing being released on July 14th, that is absolutely going to have to be one of the caveats. They're going to have to actually stop the release of that book. And if I was the defense, I would not move forward if they're going to release that book. It's going to do even worse than Howard Bloom's book, because James Patterson is a much more popular author than Howard Bloom. This is a travesty, and people are letting this stuff happen right before our very eyes. The 6th and 14th Amendments guarantee the right to a fair trial by an impartial jury. A continuance is necessary to fully investigate the leaks and to mitigate the prejudicial effects of such inflammatory pretrial publicity occurring so close to the current trial date. In sum, the 2-hour Dateline episode is uniquely prejudicial in both tone and content. It constructs a speculative narrative around motive and guilt, features emotionally manipulative production elements, and amplifies unsupported theories through self-styled expert commentary. And McDonough, those are not parentheses, those are quotations, which means she's calling your experts not experts. All the time to air just weeks before trial, when juror impressions are most vulnerable and voir dire least equipped to neutralize such deep-seated bias. The forthcoming book by James Patterson, which will arrive in the hands of potential jurors just 2 weeks prior to voir dire begins, promises to set off a new round of inflammatory, negative coverage and to deepen the pervasive bias against Mr. Kohberger on the eve of trial. The court has already acknowledged that the Dateline special exposes a likely violation of the non-dissemination order, and Mr. Patterson's purported unmatched access to sources including local law enforcement suggests that multiple unauthorized disclosures have occurred. This is big right here, y'all. Depending on the results of the investigation into the leaks, a continuance may be inadequate. Once the source or sources of the leaks are identified and full extent of misconduct revealed, the violations could warrant remedies more serious than delay. You can bet that means dismissal. At the very least, however, a continuance is essential to allow extremely prejudicial impact to partially subside and to give the court and defense time to fully investigate and address the scope of the violations. Only then can the conditions necessary for selecting an impartial jury and ensuring a fair trial under the 6th and 14th Amendments be meaningfully restored. This request is not made lightly. Defense counsel has worked around the clock, actively preparing for trial since appointment to this case, filed all motions in a timely manner, complied with expert disclosure deadlines, and had expected to proceed on schedule. However, it has become clear that without additional time, the defense cannot complete review of the necessary discovery, and that's because of the additional the additional requirements of the capital case, meaningfully respond to all the state's amended expert disclosures, and incorporate information into an effective defense, and finish critical sentencing phase investigations. Means they can't do all of that. While prompt administration of justice is important to both the state and Mr. Kohberger, the constitutional guarantee of a fair trial outweighs modest delay. And because the majority of cases ending in the death penalty are later overturned for error, the public interest lies in ensuring a fair trial in the first instance. A continuance will ensure that Mr. Kohberger's fundamental constitutional rights are honored, and that any verdict rendered rests on a fair and complete presentation of the facts, not on forced haste. Bam! Signed by none other than Ann Taylor. Good job, Ann Taylor. And I agree with all of your assessments in here. And let's wrap this up with a bow. So in a nutshell, if the state wants to keep this train on the tracks because the judge has to agree to a continuance, there's no way around it, because even the prosecution alluded to stipulating to a continuance when they were trying to preclude the death penalty. So if the judge wants to have this trial go on time, he would have to do some major stuff, or else we'll be waiting another year for this thing. The first thing he would have to do is remove the death penalty. You can bet, like I mentioned in the video yesterday, as he was in there grilling Mr. G, he was grilling Mr. G on him being one of the reasons why that death penalty is going to need to be removed in this case to get to trial. But that's not the only remedy, and I'm with the defense. I wouldn't do it unless they did all three of these. The next thing is, they can't expedite an investigation that fast. They take time, expedite getting the people to come forward who leaked the evidence, and then disqualify them as potential witnesses in the case, and any evidence that they would be testifying to that they would be laying the foundation for. That would be a requirement. And then number 3, somehow stop that James Patterson book from being released until after the trial. Those are the only 3 remedies that if I was the defense that I would agree to move forward in this case. Please like and subscribe to this channel. Post your comments, thoughts, criticisms. No video tomorrow. This one was tough enough and probably long enough for everybody to get a good watch or two in. Until then, I'll see you in a couple of days. Pavarotti's out.